Hi friends, hello. My name is Alina Shevtsova, New York immigration lawyer, and today we're going to have live discussing the most recent immigration news. Please let me know if you can hear me, type up your name, say hello, let me know where you're watching from. We're discussing today very important announcements by USCIS related to refugees in the United States and the fact that USCIS is going to review cases of all of the refugees admitted during the President Biden term. Also, we're going to talk about USPS Postmark rule change, which may be very much relevant to those of you who are filing different correspondence with USCIS, Board of Immigration Appeals, immigration courts, and we're also going to talk about USCIS premium processing fees. So thank you very much for joining. Don't forget to like and share this stream. Say hello. Let me know if you can hear me. If there are any issues with the sound, let me know. If you're watching me on Facebook and on YouTube, say hello. Very good. Thank you, Lamarck. Thank you very much. I appreciate your comment. And of course, in the end, I'm going to be answering your guys' questions. We have a lot to discuss, very important announcements. And let's start. Let's start, guys. So let me start with the first very important piece of news, basically. USCIS stated on January 9th that they will be reviewing, and in fact, they already started the process of review of all approvals of all refugees admitted into the United States from January 21st, 2021 through February 20th, 2025. What is going to happen? USCIS is going to pull out those cases and they will start reviewing the files to determine whether or not they should terminate the person's refugee status. They automatically paused such people's applications for permanent residency. They paused it already. This is in addition to all other announcements of pausing immigration benefits for people from certain countries and pausing decisions on asylum cases. So they're pausing green card applications by the refugees and they're reviewing their cases. Why? To see if they can terminate someone's refugee status, see if the status was issued in error, if a person was inadmissible or did not deserve status because a bar was supposed to have been applied. A bar to asylum or refugee status, such as mandatory bars of participation in persecution of others, mandatory bars related to certain crimes, material support, and of course, fraud. We all understand that USCIS is looking for evidence of fraud. They will be comparing records using their new databases to verify person's information, call people again for interviews to re-interview them. They're going to check what person is saying online now about their government that they fled from, and if they visited the countries, of course, countries that they received refugee status from. Very important to understand that. So USCIS started with refugees in Minnesota, and they stated that they will, after that, they will continue reviewing refugees from other countries. That's what's going on. Within 90 days, they will determine their priorities and they will move on. I would expect these new changes to be applied not only to refugees but also to asylees. Remember, there is a difference. A refugee is somebody who was admitted at the border in refugee status when they came to the United States. An asylee is someone who is receiving status of asylum in the United States. The person could have entered the United States without inspection, on a visa, on a parole, granted asylum through USCIS system or court system. This is an asylee. Refugee is a different way to receive asylum status. It's when a person asks for it from overseas. And typically, a refugee would be vetted for several years prior to them being allowed to come to the United States. So these are the people that USCIS is going to target despite the fact that they've been vetted already several times. That's what's going on. So second thing that I wanted to discuss with you, of course, concerns increase of the USCIS premium fees. The USCIS announced about a year ago, right, that they will be now adjusting their fees regularly due to inflation. And this time, starting March 1st, 2026, premium processing fees for all categories are going to go up about $160. So they will be close to $3,000 for certain applications. Premium processing fee cannot be used for family-based immigration petitions. It only can be used for employment-based cases in certain situations, not for every case. What does it mean if your case qualifies for premium fee? It means that the decision on the petition is going to be issued quickly. But if you're subject to visa bulletin wait times, the premium processing fee does not speed up that. I just want you to be very clear on this topic. And finally, USPS, United States Official Government Postal Service, is changing their postmark rule. So what is it? When you drop the mail with USPS, they stamp it when they accept it for processing, or at least that's what they've done before. And very often, you use that stamp to prove your compliance with deadlines. When we talk about various legal proceedings. But now USPS stated they will stamp the envelope not when it was dropped off, presented to USPS for mailing, but when they accepted it for their automatic processing system. What does it mean exactly? I truly do not know, except for the fact that I understand there may be a lapse in time between when you truly dropped off the mail and when they accepted it for processing. It means that sometimes your case may suffer from this discrepancy because you say that I dropped off on Saturday at 1 p.m., but because of the delays in processing, the government may say that they accepted it only on Tuesday. And you may have a very hard time proving your deadline. Thinking about this, I would advise you to use FedEx instead. That's it. So that was happening with United States immigration within the past couple of days. Now, if you guys have questions, I'll be very happy to answer them. So don't be shy. Let me know again where you're watching from and what questions you have. Thank you for liking and sharing this stream, of course. Thank you for your hearts if you're watching me on TikTok, and for your likes and stars on Facebook. Hi, Adoranceli. I am awaiting an interview date. How long would that normally take to get a date confirmed? Well, let me know what case you have. If you have an asylum case, it may take quite a while for you to receive your interview date. If you recently filed a marriage-based adjustment of status case, then it's going to take about 6 months to receive your interview. Okay? So it all depends on the type of the case. Also, if you have a marriage-based case, but also you are in removal proceedings and you are awaiting for I-130 interview date, that will take you a while to receive, much longer than 6 months. Let's see if you guys have more immigration questions. Thank you very much, guys, for your nice comments. Hi, Patrick. Hi, Rosaldo. Let's see. We are discussing immigration news, specifically the fact that USCIS is going to review refugee cases. And it's extremely important. You have to, if you're a refugee, even if you are completely innocent and have been truthful, you have to get prepared for this. You have to contact your attorney, review your records. If you filed for adjustment of status after you've been admitted in refugee status, please get yourself an attorney to potentially be ready for an interview, especially if you visited your home country for whatever reason since you were admitted into the United States. Is asylum application very hard nowadays? Hi, Joseph. I would tell you that it's harder to win asylum cases, definitely. And the reason for that would be changed precedents by the Board of Immigration Appeals, new decisions. I just today actually recorded a little video explaining how the Board of Immigration Appeals in one decision changed a decades old law with regard to qualifications for asylum based on threats to your life. We always had this rule that if you can present credible threats to your life, if they were past, if you're threatened, you would qualify for asylum. But now the Board of Immigration Appeals changed it, saying that you also have to prove that the person or persons who are making these threats actually can harm you and have an immediate ability to harm you, which is like almost impossible to prove in most situations. Hi, Gio. Did you receive any green card last month for asylum? Not countries on the list. I don't believe so. We did receive green cards for people who qualified for them based on marriage, on vow, but I don't recall having any specific grants based on asylum cases. We did receive in November, not last month, right before the ban into effect, asylum grant from asylum office after almost 11 years. The person was waiting for their asylum in the United States. Hi, always lively. That's the nickname. Hello, my husband has conditional green card with extension letter. Should he apply for N400? He is from the banned countries. I don't think so. I think nothing's going to happen. Or he will be called for an interview, but they will not be able to make a decision on the case. So I would probably wait in his situation. Again, I don't know how long this pause is going to last, right? Is there any benefit for him to file for it? I would say probably not at this point. Why? Because if something goes wrong, he may end up in removal proceedings pretty fast. So it's hard for me to give you comprehensive advice based on this little question that you are asking. But I would probably not do that for now. Okay. Hi, my I-130 got approved. What's the next process outside of the United States? Hi, OJ. If your I-130 got approved, the next step would be dealing with the National Visa Center, NVC. You would have to again collect certain documents presented to them. Your petitioner would have to file for affidavit of support. They have to prove that they have money to support you in the United States. And then you would have to wait for the interview to be noticed. And prior to that interview, you will have to submit yourself for a medical exam. So that's what is going to happen next. Okay. Hi, can asylum approved person can do adjustment of status if married to a lawful permanent resident, came legally, and PD is current. Sure. I mean, can you adjust based not on asylum but on some other ground? Yes, you can. Also, you need to know that if you are married to a US citizen and you have a green card based not on that marriage, but let's say on asylum or DV lottery, but you are married to a US citizen, you also can qualify for faster track for your citizenship, for 3-year faster track. Not, you don't have to wait all 5 years, right? So just know that as well. Let's see if we have more questions. Let me know, guys, if you have questions. We are discussing United States immigration. Hi, Mr. Hassan. This news really makes you pause and think, because behind every policy and investigations are real human lives, real families and struggles. Hope, fairness, truth, and humanity always come first. I agree with you. Listen, it's a horror show to see that we have this forced, unnecessary sufferings being inflicted on people every day. The government, any administration, truly, they have the power to make a positive change rather than the negative change. But for whatever reason, they choose the negative opposed to positive. They could have passed an immigration reform. They could have given people chance to pay fines and get back into legal status and file for these green cards. But they choose other. They choose violence, family separation, suffering. I do not know why. It just doesn't make sense to me at all. Why is the country we're focusing on negativity when we can really focus on positive changes and advancing rather than bringing this negative change to so many families, right? What's the US visa process for Australian citizens? Oh, guys, if you are residing in Australia and you are an Australian citizen, you probably can qualify for ESTA, visa waiver. Most Australians would qualify, unless, of course, you had some negative history, immigration history in your records, and you have to file for a visa and waivers. ESTA allows you to come to the United States up to 90 days without the necessity of getting the visa sticker, but it comes at a price. You will not be able to change ESTA to any other status while you are in the United States. You must depart within 90 days. You have to. And if something happens, you're found to be in violation of your status, you're not entitled to regular removal proceedings, right? Hi, I want to do adjustment of status through F2A. My spouse is in asylum status, but they were is authorized stay after B2. Adjustment of status based on F2A is not possible if you don't have lawful non-immigrant status. And asylum pending, unfortunately, is not that. So unfortunately, the person is not going to be able to adjust. Okay, they may qualify for R601A waiver, but they will not be able to adjust if the waiver is necessary. All right. You are welcome, guys. Irish people are regularly using ESTA despite many having negative histories in terms of criminality. Yes, because if you look at the ESTA questionnaire, they only ask you if you ever been found to have committed violent crimes, so crimes related to controlled substance, right? So for that reason, people with minor criminal history still may qualify for ESTA if they're not flagged in the system. That's why. Hi, Flan from Indonesia. Nice to see you here. Thank you for connecting. All right. Let's see if we have more questions. We're discussing the United States immigration news, recent news about the government yet again stopping legal immigration, focusing on trying to reveal fraud, pausing cases for refugees who were admitted into the United States during the Biden administration time. And of course, they will go beyond Minnesota. They will go probably and nationwide at some point. And of course, I guarantee you that they will also do the same with those people who received asylum status. In fact, they announced it before, right? How about if someone has zero criminal record, but he or she have final order of removal, right? Final order of removal, it means that person usually is inadmissible for at least 10 years. And to enter the United States earlier than that, such a person will need a waiver. Okay. However, if the person was ordered removed, they also may need a waiver for the initial underlying ground of removal. Maybe there was fraud, allegation of fraud, for example. Maybe there was something else, something that perpetually or forever bars person from entering the United States. So that will have to be addressed as well. But non-immigrant 212D3 waiver usually waives a lot on many inadmissibility grounds, unlike I-601 immigrant waiver. So some people who have some serious bars that prevent them from entering the United States may nevertheless enter the United States on a non-immigrant visa, but they will not be able to become green card holders. And of course, this administration may try to twist it around or something, but so far they have not changed the fact that you may qualify for a non-immigrant waiver, which is a plus, right? And guys, if you don't have any criminal history, you don't have any previous immigration violations, you will be able to enter the United States. Of course, provided that if you're entering as a non-immigrant, you do not exhibit some immigrant intent, right? Very important. Hi, Walnut. Nice to see you here. Let's see. Hi, beautiful. Hello, guys. Very nice seeing you here. Thank you for your questions. I hope you all have a safe and nice weekend. Also, something that I discussed previously. Let me see. So, approved asylum is not qualified for F2A. Approved asylum, if you were admitted as an asylee, this is a lawful status. Maybe I misunderstood your questions before. Lawful status, you should be able to qualify for adjustment in preference categories, right? Because asylum status is considered to be lawful status. When you receive a grant of asylum, you receive a new I-94, and this is your proof that you have legal status, all right? Hi, Sir Oswald III. I just don't think I will visit again for at least 3 years. I see. Okay, right. Listen, you can visit. You can visit. You should be able to visit, especially if you have family members here, friends. It's tough to stay away from your family members. As I said, the separation of family members, I think it's the absolute worst that's happening right now, right? Conferences are regularly in Florida for works, and you should be able to come. It's not that bad, okay? While it's not completely good, it's not that bad. You should be able to participate and develop your professional career. You should be able to come for conferences. Another thing that I wanted to touch base on relates to visa bonds. And I do have a video about that already, but just wanted to remind you guys that nationals and citizens of certain countries will have to post visa bonds when they come to the United States on the visitor's visa now. Again, it's something separate, not related to bans. A visa bond is an amount of money that a consular officer is going to tell you to pay if you successfully pass a visa interview. You will not have to pay it prior to applying for the visa, but only after your interview. It can be $5, $10, or $15,000, and the visa bond is like a security that you will abide by the terms of your admission. If the officer at the border tells you that you can stay in the United States for 2 weeks, you will have to leave within these 2 weeks. If they say you can stay up to 6 months, you will have to stay no more than 6 months. But if you overstay or attempt to adjust your status, and they have a very interesting example, by filing for asylum. Well, filing for asylum is not adjusting status. Legally speaking, adjusting status is when you file for a green card. The visa bond will be forfeited, meaning that the government is going to keep it. If you don't depart the United States on time, the government is going to keep the money. However, if you would not be able to use the visa, it should be automatically returned to you, this visa bond. If you denied entry at the border, it should be automatically returned to you. So that's what visa bond is. We'll see how it's going to work. I think they expand the list of the countries that would be required to citizens and nationals of which would be required to post the visa bond. And when you're going to have this visa bond situation going, you will have to enter the United States only through designated ports. I can imagine it also going to present certain inconveniences. If, for example, you're traveling to one state, now you will not be able to just choose any state to enter the United States. You will have to enter through specific ports of entry. I think it's JFK, LA, not mistaken, Dallas and Washington, if I'm not mistaken. Okay. Hi, Kiara. How long are work permits through VAWA and adjustment of status taking right now? I think it all depends, but most of work permits will be approved within about 6 months after you file for VAWA. Hello, Lucid Moreno. I was wondering what would be the steps so I could get my fiance into the country. All right, it's a good question. First, you have to meet your fiance at least once within the past 2 years. Then you have to file I-129F petition for the fiance. It has to be approved. After that, you guys will have to collect necessary documents for the fiance's visa interview. Your fiance will have to submit herself or himself for a medical exam, and they will be issued a visa. Altogether, it usually takes about a year, this process. Okay, maybe a little bit shorter sometimes. We have customs and border in Dublin, Ireland, so it saves hassle when landing as a domestic traffic. Yes, it's true. There is a pre-clearance in Ireland. I personally did not like it because it was stressful for me when I traveled to Ireland and I had to go through pre-clearance. I didn't expect it, and I remember I was like short on time, and it was, stressful. But it maybe because I didn't do my own research. I didn't do my own research. But Ireland is an absolutely beautiful country, very green, and has a very stable temperature, from what I understand. It's always almost the same temperature. Very interesting. And the food is really, really good in Ireland. Very organic, like very natural. Maybe I will get to go there again. The receipts, hi Kiara, the receipts took 5 months and we've been waiting over 9 months now and still no work permit. It depends on when you file for your VAWA. If you filed for your VAWA recently, the receipts are being issued quite quickly. But if you filed at the beginning of the year, it takes forever. I don't know why. Something happened with Vermont Service Center, It said she's underage, she's 17, she lives in Mexico, but I can't marry her yet until she's 18, or I think we'll say it. So, in fact, you probably can marry. There is emancipation rules, but you should wait. All right? You should wait till the girl is older, of course, but it's possible to, in most countries, they allow you to get married under certain exceptions once you turn 16. Hi, Sunny. My cousin has C14 EED, ICE, then two ICE arrested him. No criminal background. So the person has C14 work permit and ICE arrested them. It's possible. Well, because it seems that they have this work permit based on parole or something, right? So I'm not really surprised, unfortunately. And the good news is that even arrested, a person may still qualify for certain benefits, stay of removal, motion to reopen, things like that. So check with an immigration lawyer who worked on their case what they can do, right? You also should know that if the person is from one of those countries on a banned list, they may have limitations in terms of applying to renew their work permit and stuff. There is a lot going on right now. So reach out to your cousin's immigration lawyer if your cousin cannot do it on their behalf, and try to figure out if there is any hope for your cousin to defend themselves against the physical removal. All right? I'm a pending siege case and I'm 21 now, waiting on my green card interview. Am I at risk of getting deported? Well, you should technically be having, you said a pending siege case, so you don't have a deferred action yet, right? And you're waiting for a green card interview. So it means the siege status was approved and you filed for I-45. Are you at risk of being deported? I guess only if you commit some certain criminal act, but typically they would not go and arrest a person like you, usually, okay? So typically they will not do that. But of course, there are different circumstances sometimes, and things may happen, right? I came in F1, right? So I don't think they can summarily deport you fast, right? But can you be placed in removal proceedings? Yes. But what they're going to do with you? Probably you have to file a motion to terminate those removal proceedings. Again, I have videos about that, how these days, and I have blogs about that on my website, sholtsova.com, how these days you can end up in removal proceedings and immigration judges don't even want you to be there. They suggest that you file motion to reopen, so you are going to be bounced back to USCIS. It happens. So a lot of things changed compared to even last year, beginning of the last year. But it doesn't mean that you don't have hope, and it doesn't mean that you will be physically deported, especially if you have a good attorney who stays on top of the recent changes, sees and screens you against various defenses to removal. It helps a lot, right? Well, guys, thank you very much for joining tonight. I hope you enjoyed this live. If so, don't forget to sign up for my social media. Follow, like, of course, ask your questions and comments, and stay safe, please. Stay safe, stay calm if you have a law enforcement encounter. I've been advising this from the start of this administration, basically. The main thing is your safety, as we've seen within the past week, what's going on. Stay calm. Preferably, if you do have something going on, something filed, have on you copies of receipts, okay? If you're a green card holder, you must carry with you your green card, the actual green card. You have to have it. And I hope that you're going to reach your immigration goals and you're going to stay united with your family members in the United States. And of course, I hope to see you soon next week when again we're going to discuss immigration news and your questions. Thank you guys very much, and I hope to see you soon.